So this happened Tuesday. Chutkan's emergency injunction lands, 47 pages, 17 executive actions flagged. June 16th compliance deadline hard stop. Wednesday, Trump's legal team files a counter move nobody saw coming, 24 hours. That's all it took. You saw the alerts. Here's what they missed. According to court documents filed Wednesday morning, the administration isn't just appealing. They're pursuing a parallel legal strategy designed to functionally sidestep the district court's authority while the appeal works through the system. I've been going through the filings since early this morning, 3 documents, 61 pages combined. Here's what I found. Quick context. Donald Trump, 47th, President of the United States, currently facing an active federal injunction from District Judge Tanya Chutkan, effective Tuesday, June 9th. The issue, rather than comply with the court's June 16th deadline, the administration appears to be executing a multi-track legal strategy to neutralize the ruling before that deadline arrives. Timeline, fast version, 2 days ago, Chutkan's 47-page emergency injunction drops. 17 executive actions ordered reversed, suspended, or individually justified by noon June 16th. Yesterday, DOJ files notice of appeal to the D.C. Circuit. 48 minutes after the ruling posted, fastest response most court watchers had seen. This morning, 3 additional filings hit the docket simultaneously, different angles, same goal. That's the setup. And here's where it gets complicated, because what was filed this morning isn't just an appeal. It's a coordinated legal architecture built fast, designed to buy time. Now the documents, okay, the evidence. First document filed Wednesday. I pulled page 8. It says, quoting here, the district court lacks jurisdiction to impose compliance obligations pending appellate review. That's not spin. That's a formal jurisdictional challenge filed directly against Chutkan's authority to enforce her own order. What it means in plain English, the administration's argument is that once they filed the appeal, Chutkan's enforcement mechanism, including the compliance monitor and the June 16th deadline, is legally suspended. But here's what got me. Page 23. Different document entirely. The administration filed a separate emergency application to the D.C. Circuit requesting an administrative stay, not a full stay. An administrative stay, which requires a lower legal threshold and can be granted within hours by a single circuit judge without full panel review. That's a faster lane than anyone was watching. I went through all 3 filings twice. The strategy is layered. Track 1, jurisdictional challenge at the district level, arguing Chutkan can't enforce while appeal is pending. Track 2, emergency administrative stay application at the D.C. Circuit, targeting the compliance deadline, specifically right arrow. Track 3. We're at a 34-page Article 2, brief filed simultaneously, arguing the president's core executive authority cannot be judicially conditioned. 3 filings, same morning, all aimed at the same pressure point. June 16th, all time stamped between 7:14 a.m. and 9:52 a.m. Wednesday. Now, what nobody's covering. Page 47 of the Article 2 brief, buried in footnote 31, the filing references 4 additional executive actions part of the original 17, that the administration is proactively asserting are protected under the same Article 2 argument. Read that again. They're not just defending the 17 actions Chutkan flagged. They're expanding the legal perimeter to cover 4 more. That changes this because it signals the administration isn't playing defense, it's playing offense. Fallout came fast. Chutkan's clerk docketed all 3 filings within 2 hours. The compliance monitor filed an urgent status note to the court by noon, and the plaintiff's legal team requested an emergency response hearing, asking Chutkan to explicitly rule that her enforcement authority survives the appeal. 3 fronts opened, all before lunch Wednesday. And here's the number that matters. The D.C. Circuit's administrative stay process has no mandatory timeline. A single circuit judge can grant it in 4 hours, or let it sit for 6 days. June 16th is 6 days away. That gap is exactly what this strategy was designed to exploit. I break down what the headlines skip, 3 filings this morning. I've read all of them. Subscribe if that's useful. More coming on this as the D.C. Circuit responds. Okay, but look, got to be fair here. The other side has a point, few points actually. Trump's legal team and constitutional defenders say this isn't bypassing the court, it's using the court system exactly as designed. And honestly, the legal foundation they're standing on is real. Their argument stated fairly. First, the automatic stay doctrine. When a party appeals a federal injunction, there's a long-standing legal debate about whether enforcement is automatically paused or whether the lower court retains active jurisdiction. This isn't a fringe argument. Circuit courts have split on it. The administration is leaning into that split deliberately. Second, Article 2 is not a weak shield. The president's authority to direct executive agencies, manage personnel, and set regulatory priorities is constitutionally grounded. Multiple Supreme Court decisions over the last decade have expanded, not contracted, that authority. Defenders argue Chutkan's injunction overreached into territory the judiciary has historically left to the executive. Former Solicitor General Paul Clement argued before the Supreme Court over 100 times, has written publicly, district courts routinely overestimate their authority to bind executive action mid-appeal. Don't agree with all of it, but that's a serious legal voice making a serious argument. What they've got, states and executive authority cases before, including twice in the last 18 months. In 3 of the 17 flagged actions involve national security adjacent designations, where judicial deference to the executive has historically been strongest. Even the National Law Journal's appellate correspondent noted the jurisdictional challenge has genuine merit at the circuit level. When a publication with no stake in defending this administration acknowledges the legal argument is real, that's worth registering. Look, I'm not here to tell you who's right. The plaintiff's interpretation, documented, specific. Chutkan's ruling is detailed and evidence-based. The administration's interpretation, also documented. The legal architecture filed this morning is not improvisational. It was prepared in advance. That matters. Both things can be true simultaneously. A ruling can be legally correct and still face serious appellate challenges. What I can tell you is what the filings show. And they show an administration that came into Wednesday morning with a coordinated 3-track legal strategy ready to deploy, like within hours of the compliance clock starting. That level of preparation tells you something about how seriously they're taking this. This didn't come out of nowhere. Backstory, quick. About 2 months ago, the first signals that this administration was preparing a broad Article 2 legal theory, not just for specific orders, but as a structural argument against judicial oversight of executive management. Legal observers flagged it. No formal filing yet. About 6 weeks ago, the executive actions at the center of Chutkan's ruling begin rolling out fast. 17 actions in 29 days, each one moving without the standard notice and comment process. About 3 weeks ago, internal DOJ memos, later obtained through FOIA, show career attorneys raising procedural concerns. The memos were acknowledged. Actions proceeded anyway. A former Deputy Assistant Attorney General who served under 2 administrations said, on record, flooding the zone with filings is a deliberate appellate strategy. Volume creates delay. What happened between those internal flags and Wednesday morning? A legal team was assembled. Arguments were drafted. The Article 2 brief alone runs 34 pages. That's not written overnight. Pattern across the past 2 months. Arrow actions taken without standard legal process. Arrow internal concerns raised and overridden Arrow. Appeals strategy prepared in parallel with the actions themselves. Every step calculated. Until Chutkan's ruling forced the timeline following the trail. Hit like. It signals the breakdown is useful and helps this reach people actually trying to understand what's in these documents, not just the headlines. Wednesday, 11:23 a.m. Eastern. Here's what happened. Chutkan's courtroom received the plaintiff's emergency response request, asking the judge to formally rule that her enforcement authority survives the appeal and that the June 16th deadline stands regardless of the D.C. Circuit's administrative stay timeline. The court's jurisdiction is not suspended by a notice of appeal. That's the plaintiff's core argument. Filed in writing on the record, courtroom reaction, immediate. What followed? Chutkan issued a same-day order scheduling an emergency status conference for Thursday, June 11th at 10 a.m. The compliance monitor filed a supplemental note confirming all 17 actions remain non-compliant as of Wednesday noon. Arrow DOJ attorneys requested a 48-hour extension to respond, denied within 31 minutes. 31 minutes. That fast. Now, what everyone missed. While coverage focused on the jurisdictional fight, something else landed quietly in the docket. The administration's Article 2 brief contains a section, pages 28 through 33, that doesn't address Chutkan's ruling at all. It addresses a different court, different jurisdiction. It's a preemptive legal argument structured for Supreme Court review. Not the D.C. Circuit, the Supreme Court. Then it clicked. The three-track strategy filed this morning isn't just about June 16th. Track 1 and Track 2 are about the deadline. Track 3, the Article 2 brief, is about the long game. Chutkan understood it immediately. Same-day emergency conference, denied extension request, 31 minutes. She's not waiting, neither are they. This is where it gets interesting. Don't go anywhere. What I show next changes the picture. Drop your prediction in the comments. Does the D.C. Circuit grant the administrative stay before June 16th? Then keep watching. I'll tell you what the experts are saying. What are experts saying? Former assistant U.S. attorney with 19 years in the D.C. Circuit handled appellate emergency motions specifically. Administrative stays at the circuit level are not rare, but timing them against a hard compliance deadline is tactically aggressive. Plain English, the strategy is legally legitimate, but using it to run out the clock on a court-ordered deadline is a pressure move, not just a procedural one. Another one, separation of powers scholar at University of Chicago Law, testified before the Senate Judiciary Committee twice. The Article 2 brief is written for 9 justices, not 3 circuit judges. That's unusual at this stage. Key there, the administration is already arguing past the D.C. Circuit. They're building a Supreme Court record before the circuit has even ruled. That's a signal about where they think this ultimately lands. Here's what's interesting. Even a former Republican-appointed D.C. Circuit judge who has publicly supported broad executive authority said this week, filing 3 simultaneous tracks creates procedural complexity that benefits the filer, not the court. When a judge sympathetic to the administration's position acknowledges the strategy is designed to create complexity, pay attention, consensus among appellate specialists. The administrative stay application is the immediate threat to Chutkan's June 16th deadline. 6:30 circa starate Faubrai Andarsau Sakit Judges have wide discretion on timing leads to the jurisdictional challenge at the district level is unlikely to succeed, but forces Chutkan to formally rule on it, consuming time, the Article 2 brief signals. Supreme Court preparation, regardless of circuit outcome, that's where professionals land this Wednesday. If this breakdown is useful, hit like. These document breakdowns take time. That like button tells me to keep going deeper on this story. Why should you care? Real talk, how this affects actual people. If you receive federal grants, operate under federal contracts, or work for any of the agencies named in Chutkan's ruling, pay attention. The $340 million placed back into the disbursement pipeline by Tuesday's ruling, its status is now legally uncertain. Here's why. If the D.C. Circuit grants even a temporary administrative stay, the compliance monitor's authority is suspended. Funds moving back into disbursement could pause again. Pending the stay's scope. Right now, program officers at 14 federal agencies are being told to hold disbursement decisions until Thursday's status conference clarifies the legal picture. Your practical situation, if you are counting on that funding resuming before June 16th, Thursday's hearing matters more than the deadline itself. This sets a precedent beyond this case. Next time any federal court issues an injunction against executive action, the administration has now filed a public legal blueprint for challenging enforcement while appeal is pending. Quick example, an environmental agency is ordered to reinstate a regulatory process. The administration runs the same three-track strategy: administrative stay by 6 to 12 days, jurisdictional challenge consumes another week. By the time the circuit rules, the regulatory window has closed. Not dramatic. That's how legal strategy works when you have the resources to run three tracks simultaneously. Right now, 2.3 million federal employees and contractors operate under agencies named in the original ruling. State budget offices in 14 states paused their own funding projections Wednesday afternoon, pending Thursday's hearing. It hits within 72 hours. That's the real clock, uncomfortable part. This case is no longer just about 17 executive actions. It's about whether a district court can enforce an injunction against the executive branch when the executive branch contests jurisdiction. That question affects every future administration, every future court order, every future injunction. If you pay federal taxes, vote in federal elections, or depend on any federally funded service, the answer matters to you directly. What informed people are doing right now? Federal grant recipients are contacting program officers Wednesday and Thursday before the status conference. Legal teams at affected agencies are reviewing the jurisdictional challenge filing to assess compliance exposure. Arrow. Ask your attorney, does the administrative stay application affect my specific contract or grant disbursement? Knowledge helps. All three filings are public record. How did Trump respond publicly? Leaned in, hard. A Wednesday afternoon, a formal White House statement described Chutkan's ruling as a judicial power grab with no basis in constitutional law, and called the administration's filings the appropriate and necessary defense of Article 2 authority. Quote, no district court can sit back and just to say the executive branch. Reaction. The statement was amplified across conservative media within the hours, framing the legal filings as a political victory rather than a procedural maneuver. Chutkan's court received 3 additional amicus brief requests within 4 hours, all from civil liberties organizations seeking to file in support of the injunction. The plaintiff's lead counsel responded directly. Rhetoric about Article 2 doesn't change the compliance deadline. June 16th stands. Then the next development. Late Wednesday afternoon, Senate Judiciary Committee Chairman Dick Durbin issued a formal letter to the DOJ requesting a briefing on the jurisdictional challenge filing, specifically asking whether career DOJ attorneys were consulted before the filing or whether it was directed by political appointees. That letter creates a separate congressional oversight track running parallel to the court proceedings. Not one story anymore. 3 simultaneous fronts heating up. What's still unclear? 1, whether the D.C. Circuit assigns the administrative stay application to a single emergency motions judge or routes it to a full 3-judge panel. Single judge can rule in hours. Panel process takes days. That procedural decision not sounds determines whether June 16th survives. 2, the scope of Thursday's emergency status conference. Chutkan scheduled it for 10 a.m., but hasn't published an agenda. Whether she rules from the bench on the jurisdictional challenge or simply sets a briefing schedule changes everything about the next 72 hours. Coming Thursday, June 11th at 10 a.m., Chutkan's emergency status conference, most important hearing of the week. Friday, June 13th, D.C. Circuit expected to respond to administrative stay application. Sunday, June 15th. Plaintiff's deadline to file opposition to the jurisdictional challenge. Date to watch. Thursday morning. That's where the June 16th deadline either holds or fractures. Should know significantly more by Thursday afternoon. I'll cover Thursday's status conference as soon as the transcript drops. Subscribe and turn on notifications. Whatever Chutkan rules Thursday morning, I'll break it down the same day. That hearing is the pivot point for everything that follows. Where we are right now, Wednesday, June 10th, Chutkan's emergency injunction remains active and in force. 3 administration filings hit the docket this morning. Jurisdictional challenge, administrative stay application, Article 2, brief. Arrow. D.C. Circuit has the administrative stay application, no ruling yet. Arrow emergency status conference scheduled Thursday, June 11th, 10 a.m. Arrow Compliance Monitor confirmed all 17 actions remain non-compliant as of Wednesday noon. Senate Judiciary Committee letter to DOJ requesting briefing on jurisdictional challenge filings, scheduled Thursday, June 11th, 10 a.m., Chutkan Emergency Status Conference, Friday, June 13th, D.C. Circuit, expect response on administrative stay, Sunday, June 15th, plaintiff's opposition deadline to jurisdictional challenge, Monday, June 16th, noon Eastern, hard compliance deadline, currently still in force. Not public yet whether the Supreme Court has received any informal communication about the Article 2 brief or potential certiorari preparation. No confirmation. But the brief's structure suggests it. Clock's running. That's where we are. Trump's legal team. 3 filings, 3 tracks, 1 Wednesday morning. Surface, read, and administration fighting back against a court order. But the Article 2 brief written for 9 justices, not 3 circuit judges, is the document I keep coming back to. That's not a response to Chutkan. That's preparation for a different court entirely. And the Senate Judiciary letter adds a congressional oversight dimension that wasn't in the picture 48 hours ago. This isn't staying in one branch or one courthouse. I'll be watching Thursday's status conference specifically. What Chutkan rules from the bench, or doesn't rule, Kyan Sadao will tell you more about where this goes than any of the filings themselves. Stories not over, still developing. Subscribe for the full picture, not just the alerts. When documents drop, I'll break them down. Talk soon.